Hearing in the appeal, Seebun and Domun and others.
Right, Mrs. Sukun, is that right? Can you hear us?
Yes, it is, my lord.
Thank you very much.
I can
think
hear you.
You'll stay seated, I hope, so we can see you.
Yes.
Right, well, would you like
Yes,
to...
we shall be seated.
Yes. Would you like to introduce the case? Introduce who else is there?
Yes. Indeed, my lord. Very good morning to you, my lord and my lady. I appear for the appellant instructed by Stephen Associates Law Firm, and I have been instructed, and I have Mr. Stephen Sengayan on my right, and for the respondent, my learned friend, Mr. Madan Dalu, appears for the respondent on my left and is instructed by attorney Mr. Pazani Rengasamy.
Thank you very much.
Who is...
Well, we've read, I can tell you that we've been working from the hard copy pagination. We've read the judgment of the Supreme Court, which appears, I think, on page 159 of our bundle. And we've read the Court of Appeals judgment, which appears on 262 of our bundle. And we've read both your cases, your helpful case, and your colleague's case for the respondents, and we've familiarized ourselves with the facts. So, and also we've seen the answers to the questions raised by the court, which we've got a note of the answers from the respondents. I think you're going to deal with them in your submissions. Is that right?
Yes, indeed, my lord. I will be taking them along in my submissions.
Yes.
Just firstly, I will be producing additional documents which have been filed only yesterday, and they will be added at page 176 of the electronic bundle. These are documents which were not legible in the bundle, and it's
Well, look,
page 176.
would you like to, I think, do you want to come to those later? I mean, would you like to, I think, could you open your case, and then when you need to put in documents, we'll need to make sure we've got the right documents. All right?
Okay. Yes, my lord. Yes, my lord. So, indeed, my lord, I do propose to submit directly on the grounds of appeal that has been raised before your lordship. And alongside with the grounds of appeal, I will be also addressing to the queries as and when they refer to. And finally, I will have a few reply to the respondent's written case, as there have been issues which have been raised and they do not form part of the grounds of appeal. So when it will be necessary, I will be also addressing them just to enable the lordships with a reply for my friend's written case. On the very first ground, my lord, my lady, which that their lordships in the Court of Civil Appeal found that the plaintiff summons did not disclose a cause of action based on occupation for more than 30 years by lately Kakawal and the plaintiff. My lord, my lady, I intend to reply to this by 4 different aspects. The very first one will be, I will take your lordship to the plaintiff summons, the second amended plaintiff summons, which is found at page 37.
Yes, we
Of
got
the
bundle.
Original bundle.
Yes.
Yes.
Well, we've got there the second amended plaintiff summons. Yes.
Yes. Yes, my lord. And when we look at even though their lordships reproduce extensively in their judgment the whole plaint, it is submitted that they nevertheless missed out the very cause of the action of the appellant. At paragraph 2 of the plaintiff summons, my lord, my lady, if we look at the wordings that have been utilized all throughout the plaint, there is one word which have been very common all throughout, and these are, at paragraph 2, late Lekha Kawal had occupied.
Yes.
And it describes how it had occupied. And when we read in at paragraph 3, the very same words that to the effect on the second sentence of paragraph 3, my lord and my lady, that they caused an affidavit of prescription to be affirmed that he has become owner of a portion of land referred. And they say for having occupied for more than 30 years.
Yes. Can I
When
just...
we are taken all throughout the plain, therefore, my lord, my lady, we see that even at paragraph 6, 7, 8, and even at 9, the words have always been, he has become owner, either by way of the acquisitive prescription or he had already become owner. And at paragraph 7, that had already become the rightful owner of the said portion of land. At
Ms.
paragraph
Seebun,
8...
could I stop you just a moment? You need to sort of keep an eye on us. If we want to interrupt, we'll probably raise a hand or something like that. But that's very clear.
Yeah.
When you say he had become owner by virtue of 30 years occupation, is that
Yes.
up to 1976? Is that the critical date?
Yes,
I mean,
my lord, up to
as I understand it, you were
1976.
relying on 30
Yes.
years occupation up to 1976. Is that right?
After, yes, as at 1976, the law required only 20 years of occupation.
Yes.
And then the law was amended after 1982. I believe it became in application, 1984, my lord.
Yeah.
Then after 1984, it became 30 years of occupation.
But when you're talking here in your plaint about 30 years occupation, what period are you talking about? What is the end date of that?
It is all before 1976, my lord.
So you're asserting 30 years, although you only needed 20 years at the time. Is that right?
Yes. As at 1976, the law required 20 years.
Yes.
It is the submission, and because the law had changed thereafter, and this plaint was brought before the court in the year 2003, for that period, for the claim in 2003, it was important for the appellant to put in a plaint where it was requesting acquisitive prescription for 30 years. It is the submission of the appellant that even as at 1976, irrespective of the averments in the affidavit of prescription, the appellant had occupied it for 30 years.
Right, thank you.
Although yes, okay, thank you, my lord. I was referring to the wordings in the plaintiff's summons, my lord, and that would be the very first reason that it is the submission of the appellant that their lordships at the Civil Court of Appeal misdirected themselves into construing that the plaintiff did not disclose a case of occupation by way of acquisitive prescription. The second reason is the structure and the manner in which this plaintiff summons has been drafted, my lords and my lady. It goes very as describing who are the person who are coming to claim on behalf of late Lekha Kawal that they have become owners through occupation. The plaintiff describes the heirs, and there was a question raised as to the stance of the appellant's siblings and co-heirs in relation to the proceedings. In fact, all the co-heirs and the heirs are together, and they are awaiting and they consent that the appellant, S. Seebun, represents them all, and they are all awaiting that they are declared a rightful owner of the said property. So they are all agreeable and they are aware that this matter is coming before court to establish ownership. This is done in paragraph 1. Yes, my lord.
Lord Hodge has a question.
Yes.
I want to understand that you say you have the express, not just the tacit consent of the other owners, you say they're owners, to raise these proceedings. Is that right?
They are claiming themselves to be the owners, yes, my lord.
Yes, but as well as the appellant, you are saying the appellant obtained from his siblings Atmaran Kawal and Sita Kawal their consent to raise the proceedings, or they have consented to the continuation of the proceedings. Is that right?
Yes, they have always been they have always, ever since even in 2003, they were consenting to the proceedings. However, the proceedings were not put on the name of everyone. It is only the plaintiff who put forward the case.
Yes, thank you.
Yes, my lord. The paragraph 1, they describe who are claiming on behalf of late Lekakawal. In paragraph 2, this is where the wordings again utilized establishes the plaintiff summons by way of acquisitive ownership, because, my lords and my lady, all the requisites of the prescription, if we look at paragraph 2, for more than 30 years in a peaceful, public, continuous, uninterrupted, unequivocal, animo domini, à titre de propriétaire, and in an apparent manner. These words, my lord and my lady, are all words that are utilized under Article 2229 of the Civil Code, and they are legal requirements that needs to be established before the court in order that a claimant can come and establish its case, that it is asking for the court to declare that they have been in possession and have acquired by way of prescriptive acquisition. These words that have been used in this paragraph, we cannot accept the conclusion reached by their lordships in the Court of Civil Appeal that this plaint did not disclose same. The third reason that I would submit, my lord and my lady, that the plaint does sufficiently disclose this course of action is, after having explained the property and the requisites required under Article 2229, the memorandum of survey is put here in order to establish which property is being referred to. There is an issue that has been raised about the memorandum of survey, as well as the LS numbers, my lords and my lady. I shall address this point at a later stage. And also the name of Kelawan Domun having been inscribed at paragraph C, which may have led to certain confusion as to the boundaries of the land. This issue also I will be addressing at a later stage. Then in paragraph 3, the plaint carries on, and in all fairness to the application, the plaintiff discloses that there was an affidavit of prescription, and that this affidavit of prescription has been placed before the conservator of mortgage. They have also, in all fairness and in good faith, reproduced the objections that have been raised by the respondent at that stage before the conservator of mortgage. Had the plaintiff not described about this application that they had made before the conservator of mortgage and not disclosed them, it would have been a plaintiff coming before the court without being of good faith. And this is the very reason the paragraph 3, 4, and 5 have all been put, and they have not been denied by the respondents. In fact, at paragraph 5 in the plea, wherever all the objections have been placed, my lord and my lady, in the plea, they admit and they even maintain the averments that have been put in the plaint.
The,
Yes, my lord.
yes, the text in paragraph 5 of the objection, how was the plaintiff able to plead that if the objection wasn't extant?
They were able to plead it at that time because I believe, my lord, that they had a copy of the objections before the conservator mortgage in those days, 2003.
Yes, thank you.
In addition, my lord, then the plaintiff even avers what has been the objection raised by defendant number 2 and 3, and they also stated a reply to the objection that their objections were unjustified and frivolous affidavit, but they replied that late Lekha Kawal had occupied same and he had consequently already become owner. At paragraph 7, they then declare it is essential, paragraph 7, my lords, because the plaintiff avers that late Lekha Kawal had already become rightful owner. And the words that are very essential here, my lord, is that the land described at paragraph 2 by acquisitive prescription. The plaintiff does not come before court to say that late Lekha Kawal had become rightful owner by way of paragraph 3, because it is paragraph 3 that mention is made about the affidavit or prescription. And paragraph 8, my lord, is to the effect that since late Lekha Kawal had already passed away at the time that this plaint was being entered, then the plaintiff had to put its stance, and he requested the court as a heir. He has also what he has done as a heir, and he has been in occupation of the said property. And at paragraph 9, the prayers makes it very clear, my lord, that the plaintiff, together with the heirs, were requesting the court to decree them that they had become owner. When they asked the ordering the conservator of mortgage and restraining the defendants from interfering with the peaceful enjoyment and occupation, my lord, it is the submission of the, on behalf of the appellant, that requesting the order for the conservator of mortgage to have it transcribed, whenever a immovable property or a property is concerned and is a subject matter before a court of law, and there is a title deed or there will be eventually a title deed, it is essential that if there is any document in such as the conservator or mortgage office, that whatever be the outcome of the court, same outcome should be communicated to the conservator of mortgage. There is the Transcription and Mortgages Act, and there's the Prescription of Affidavit Act, which would be referred to, because this is a case where, because they had gone and submitted the affidavit or prescription already, it could not be withdrawn from there. The only possible way to remedy or to make things go as they are, it was important to request the court to inform the office of the conservator of mortgage and to take the necessary action. The conservator of mortgage has a duty of transcribing judgments, either positive or negative judgments, my lord. It is not that because they requested for this prayer that the plaintiff summons changes its modality from asking an acquisition, prescriptive acquisition, to only an affidavit of prescription case, my lord.
Sorry,
When
can I just,
the
Ms.
yes,
Sukan, can I
yes,
just
my lord?
understand, the problem that the Court of Appeal seemed to have seen was that you couldn't order the conservator to transcribe the affidavit of prescription if you didn't have the affidavit of prescription. I mean, I can see you could ask for an order that you own the land, but for the purpose of transcribing the affidavit, if you didn't have it and it wasn't before the court, how could an order be made about that?
Yes, indeed, my lord. To that, my lord, I will submit that because the plaintiff was bringing a case based on acquisitive prescription and occupation, they have been in a way, when they have also mentioned at paragraph 3 that there has been this affidavit of prescription, they have asked for the conservator mortgage without producing the said affidavit, that same be transcribed. Indeed. However, if the judgment of their lordship would have been to agree on the acquisitive prescription, then the affidavit of prescription, whether it's transcribed or it is not transcribed, it would be of no negative effect on the plaintiff's property rights, because the trial judge would have, in a way, is the greater includes the lesser. If the trial court has accepted that the ownership is acquired by occupation, then it is not even essential to have the said affidavit be transcribed.
I think Lord Hodge has a question.
Yes. So you accept that you do not have, and the conservator of mortgages does not have, a copy of this particular affidavit?
We do not have it in our possession, my lords. After being requested to ask, we have made our search. We do not have it, but I believe the conservator of mortgage should have it.
Well, you don't know. I mean, I'd be surprised if the conservator has got it, because I would have thought if he had it, we would have seen it.
But in any event, we don't know its terms. We don't know whether or not it complies with the statutory requirement in the Affidavits of Prescription Act. So I don't see at the moment how we can make the order that you seek under paragraph 9C of the second amended plaint. That said, you say, and maybe with some force, that your claim is for acquisitive prescription by occupation, and that you are entitled to a decree in terms of paragraph 9b and paragraph 9d in any event. Is that your position? Yes.
Yes, my lord.
And if this court were satisfied that it were proper to do that, would you then be able to, your client be able to create, founding on the court's decree, an application to have an affidavit of prescription in order to get a document as a link in title?
Sorry, my lord, there were a few words that were not clear, but if I understand, if there was an order under paragraph B, if I get your question, is that whether we would not be insisting on paragraph C?
Well, I don't see how you can insist on paragraph C with respect, because we cannot order the conservator to transcribe something which we don't know complies or doesn't comply with the statutory requirements. So
yes, indeed.
I, for one, my colleagues may have a different view, but I, for one, cannot see how we can pronounce an order under paragraph C. But that is without prejudice to your entitlement to an order under paragraph 9b. And if you did get
yes,
an order,
my lord,
Yeah. If you did get an order under paragraph 9b, would you then be in a position to lodge a fresh affidavit of prescription founding on the court's order?
My lord, it would not be necessary because the judgment, yes, the judgment, we can have it under the, I have the transcription of Mortgages Act somewhere later in my submissions, whereby the judgment can be transcribed and it gives a title deed to a claimant.
Thank you.
Thank you. Right, carry on.
Yes. So therefore, my lord, coming back to the ground number one, it is my submission that prayers C may have been extraneous and additional, but it does not mean that there is no claim, no plaint for asking occupation by way of prescriptive acquisition. The paragraph D, my lord, was necessary because there has been a case, a judgment before the District Court of Mocha years ago in 1982 for the defendant in the other case, which is found at, it is a document G, the judgment of Mocha Court. And the defendant there did not respect the breach,
This is document G. I think it's page 175 of the paper bundle.
Thank you, my lord. Yes, indeed. It is indeed at page 175, my lord. In this case, my lord, Lekha Kowal, in the year 1980, and the case was against Anand Domun. And they had also there established, the plaintiff tried to establish his occupation. He won the case. Late Lekha Kowal won the case, obtained damages to the amount of 4,000 plus something, and there was a further order made by the district magistrate at page 175, and the last just before the signature of the learned magistrate, whereby the learned magistrate ordered, I further order the defendant not to commit any trespass on the land in future. The court had already, if we take this judgment, it was in a form of an autorité de la chose jugée. So already it was decided by the court that Lekha Kowal was rightly a rightful occupier and he should not be interfered in the enjoyment of this property. But because they had continuously been not allowed to enjoy their property, it was necessary to request from the Supreme Court, because District Court of Mocha is a court of a lower jurisdiction, and Supreme Court trial is of a higher jurisdiction than the District Court. Therefore, it was essential to reiterate the prayer, and since the defendants here were different defendants, albeit Domun family, but they had to request for the prayer of restraining and prohibiting the defendants from interfering with the plaintiff's occupation. At the same time, again, if we succeed on paragraph B of the prayer, paragraph A becomes superficial. The prayer at paragraph A. However, in the nature or the way the plaint was set and was presented before the court, the plaintiff invited to look into the objections raised and whether they were satisfactory or not to disprove the ownership by way of acquisitive prescription. Therefore, my lords, these are the reasons I humbly submit that their lordships in this Court of Civil Appeal misdirected themselves when they concluded that the plaintiff did not disclose a case based on acquisitive prescription. The last submission on this very ground is to the effect that all the witnesses and the proceedings and the examination in chief during the trial, my lord, they all took place without any objection on behalf of the respondents. They did not even, when they cross-examined the witnesses of the plaintiff, who all came to depone and establish 30 years of occupation, or rather, let's say peaceful occupation, the respondents also only cross-examine them to the extent of whether they were rightfully occupying it or not. And last but not least, my lord, on this point, had the plaintiff summons not disclosed the proper course of action, and this point I will be taking it for all other points that have been raised for the very first time by the respondent on appeal. Issues such as these, that a plaintiff does not disclose a course of action, should always be taken by way of a plea in limine. Therefore, before the proceedings on the merits start, all arguments in law are exhausted. Suffice it to say that if they are not taken at an early stage, they may be taken because they are points of law, they may be taken during the proceedings. At the trial stage, not on an appeal. There have been several points that have been raised on appeal for the very first time by the respondents, and to this, the submission of the appellant is to all the points that have been raised on the first time that they should not have been allowed, and they are not allowed because the plaintiff, the then plaintiff and the appellant have been unable to meet in the defense of such points that have been raised on appeal. And this is where, my lord, had the plaintiff summons not disclose a course of action by way of acquisitive prescription, it was essential for the defendant then to take that point before the trial court so as not to commit an abuse of process and to deal with the issue then and there, not so that the plaintiff then would not have been calling all these witnesses before court. And it is with this respect, I will take one of the points that have been raised by your lordships, and that was with regard to extinctive prescription. Whilst there is acquisitive prescription, I understand that the extinctive prescription would be where there is a time limit bar to enter a particular action. So, even if the case, had it been a case where it was prescribed by, let's say, 10 years, that point ought to have been raised by the then respondents' defendants. They will not be raised by the court of law, by the trial judge, simply because maybe the trial judge, as he did not see that there was a different course of action. But if the trial judge notices that there is an issue of law and there might be a prescriptive time bar, the trial judge would indicate same to the lawyers, and legal advisors will then submit on the time prescription raised by the court. In this matter, there was no such plea in limine raised. Yes, my lord. Yes.
Against your point about extinctive prescription, I think the respondents cite Article 2224 of the Code, which says that the prescription can be opposed at any stage of the cause, both before the tribunal, including the Tribunal of Appeal. I see the force of your point about no attack on the cause of action and no attack on the title of the appellant himself to sue on behalf of his co-heirs. But in relation to extinctive prescription, would it not be right to say that 2224 allows prescription a challenge to be made? Or have I misread that?
Yes.
We have 224.
Yes, my lord. À moins que la partie qui n'aurait pas opposé le moyen de la prescription ne
Hang on a
doivent
moment.
être présumées. C'est ça, my lord.
I'm
Yes.
not sure
yes.
we've got 2224.
I issued
We have.
one.
Yes, in fact, my lord, these are the submissions that the reply that have been given a late night yesterday, and I am also taken cognizance of this
Thank
only
you.
now.
I have it.
Yes, indeed, and it is.
So
yes.
2224,
And
you were reading.
it
Yes.
is at third page.
Yes, thank you.
The third page of, yes, and it is the last article.
Yes,
This is where the case of, in order, because this is in French, and if we look at the case of Ramdani, just
Right, can we
above
just-
the articles
Can
have
we
been,
look first at 2224, which I've now got, and that
Yes.
appears to suggest
Yes.
that the objection can be taken even in front of the Court of Appeal. Is that right?
yes, indeed, my lord, indeed. However, there is a condition. À moins que la partie qui n'aurait pas opposé le moyen de la prescription ne doive, par les circonstances, être présumée y avoir renoncé. So this is where if we go to the, there is this condition, my lord. And if we read in Ramdani, just above article 2223, there is a case that have been cited by my learned friend. And in that case, it explains when the issue can be taken. So it is only in anticipation, my lords, am I able to quote?
Yes, well,
Are
you're
we
now.
all in the case of Ramdani? Yes.
Is that
Yes.
case in the
the
bundle?
Ramdani case,
Sorry?
yes.
Is the case in our
So it's
bundle
in
of
the
authorities?
same, it's the same document that has been replied and where we were looking at Article 2224.
Yes.
Yes. Are you looking at the respondent's reply which came yesterday? Yes.
Yes, indeed,
And,
my lord.
and there,
Yes,
above the
indeed.
articles, there's a quotation from Ramdani. Is it that you're referring to?
Case.
Thank you.
Yes, indeed, my lord. It's for ease of reference to understand the condition.
Yes.
The condition that has been imposed where the prescription might be utilized. It states, my lord, that the last line, the defense of prescription to the action could only have been raised or waived by the appellants once the period of prescription had run. Therefore, and in just above the third, I'm sorry for going up and down, my lord. It's only because I've got this document earlier today.
Yeah.
If we go to the second sentence, we find that we also know Article 22-23, the court cannot consider d'office. So by itself, the question of prescription.
Yeah.
And therefore, Article 22-23 dispars the court from taking into account the question of prescription. However, it can be waived once the period of prescription had run. In the present case, we do not agree that this is an action personnelle and that the 10 years have already lapsed. So we would not be accepting the application of Article 22-24.
Right, thank you.
I don't think we have
Yes.
the case of Ramdani in the full text.
Yeah.
We just have this quotation, is that right?
No, there is the case of Ramdani, which is at the back in the same bundle.
Oh, I apologise.
My lord.
Oh, yes,
which
you're
is-
right.
Yes,
You're right. You're
it
right
has-
indeed. I did see
yes,
it.
Yes.
Yes, thank you.
However, the translation of bits and pieces in French we have not been able to do it because of the very late reply and submission of this document, my lords, my lady.
Yes. It may not matter anyway, but I just wish to have your position on that. Thank you.
Right,
Yes,
so where do we go from there?
So, yeah, this is my the first ground of appeal, my lord, and I now move to the second ground of appeal. The second ground of appeal that was raised, my lord, is that the cause of the plaint was in respect of the transcription of the affidavit of prescription. To this ground, I will join my submissions that I have made for the first ground, because the first ground was to the effect that it's acquisitive prescription and it is not solely for the transcription of the prescription of the affidavit. Based on the submissions I have just made for the first ground, my lord, I have to add that the way the appellant conducted the case before the trial court by calling all witnesses to establish his occupation, the plaintiff appellant did not call evidence to substantiate his affidavit or prescription, whilst he may have also done that. But he did not choose to do that. This was because primarily his case was not on the basis of transcription of this affidavit.
Yes, he would. The establishment of acquisitive prescription is a step that was needed before he could justify the affidavit. So your position, as I understand it, is this was a claim for acquisitive prescription, which would lead to the transcription of the affidavit if the affidavit were available.
Yes and no, my lord, because at that time the law had changed. The affidavit of prescription, if it would have contained the number of years, and even the affirmance would have been for 20 years only.
Yes.
And coming to court in the year when the time has changed, when the lapse of time for ownership, occupation had changed, it would have been improper anyway to ask for the transcription of this affidavit to obtain a right.
But your point, and I see the force of it, is that it is wrong to characterise this action, standing the request in 9b and 9d, it is wrong to characterise this action as an action solely concerned with the affidavit of prescription.
Indeed, my lord.
Yes.
Indeed. Indeed.
That's your ground. That's ground
Because
two.
yes.
All right.
Yes. And so that disposes also of the ground too, my lord. Suffice it to say that the ground of objection before the conservator mortgage, there is one aspect which have been raised by your lordships as well, and that was the house built by defendant number 2 and 3. If we look at page 38 of the bundle, my lords and my lady, the defendants, then the respondents today, raised the objection on the affidavit that they had their house on the said plot of land. However, all throughout the proceedings, my lord, such situation has not been established. And if I may be allowed to take the queries raised about the house and to take your lordship at this stage itself to the different depositions of the witnesses, disproving this element, my lord, that the defendants never had their house on this disputed land.
Yes, I think a distinction has to be drawn between the 87.5 purchase, which was the title of the respondents, and the appellant's claim to occupation of less than half of that, namely 37 and 2/3 purchase. And is it your position that the house that is described in the contract of sale as being in the course of being built wasn't established as being on the land that the appellant claims title to by virtue of occupation?
My lord, thank you for raising this point. The defendant never establishes before the trial court where in fact its house or the construction of the houses are situated. They do not establish before this court, whereas it is the claim of the plaintiff appellant that on this 37 3/4 purchase, which is out of the 87 bigger portion of land, there is no such construction of the defendant. And when they were asked questions, if I may take your lordship to the bundle, the first bundle where the depositions of the witnesses are, at page 102, my lord and my lady.
Who is giving evidence?
At page 1, yes. Yes, at
this
page
is
101, yes.
Is this the evidence of the appellant?
This is of the appellant, Mr. Seebun, and it is found at page 344 of the translated. The translation happens at page 344, my lords, my lady.
Yes.
Oh, sorry. Yes. And the then plaintiff appellant was being cross-examined by Mr. Birou.
Yes.
Sorry, my lord. I'm just taking where it was in Creole language.
I think 351 is the equivalent of 102.
Yes, 351. Yes, indeed, my lord. The 102 comes at 350. Yes, 350 and 351.
Thank you.
So what are we looking at? Page 350, 51.
Yes, 350 and 351, my lord. When the appellant was being cross-examined by counsel at page 20, line 20. And the question was, I am telling you that there is a house there and that defendants reside on that land. And it says that it forms part of this larger plot. What do you have to say? And counsel for the plaintiff stated that the counsel was misleading. And at page 351, then he was requested to rephrase his question, and to which bit Mr. Birou replied, all right. And he did not pursue, my lord, my lady, with the question that there was a house, rightly indeed so, because there was no house on this 37 3/4 purchase. That is the first aspect in relation to the house. There are also questions that was put to the plaintiff. Mr. At record 141, but 141 would be the translated would come at as from page 381, my lord, my lady.
Yes. This is the cross-examination
Yes.
of Mr. Domun, the defendant.
Mr. Domun, yes, yes. And I would refer to, show me.
Is it the question at the bottom of 381? You live near, there was sugarcane all the time on that land. Today there is sugarcane, yes or no?
Indeed.
The answer, yes.
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 Yes, thank you, my lord.
Yes, that's lines 18 and 19 on page 141, around there.
Well, yes, indeed, 141,
Yes.
I mean between 10 and 14. Yes, my lord.
10, 14, sorry, yes, yes.
But on page 381, it's at the bottom, line 20. Is it? So that's showing that there was sugarcane on the land. And is there any
Yes.
mention of a house?
And no, he mentions only sugarcane, my lord.
I see.
But it would be for him to prove where he lived.
Sorry, my lord.
I just said it would be for him. The
At
burden
page
of
3.
proof.
Yes.
Hang on a moment. Lady Arden has a question. Could you
Yes,
put it again?
sorry.
The burden of proof would be on him to show where he lived, even though it was a claim for acquisitive prescription. This fact had to be proved by the defendants.
Yes.
Yes,
Yes,
the
my
defendant had
lady,
to
because
show,
they
if he had a house,
raised-
he had to show where it
Yes.
was.
Yeah, thank you.
Yes.
That's all.
And they had raised it as one of the objections
That's
it.
to the affidavit of prescription before the conservator of mortgage, and which is quite in the plea. The defendants never mention in any of the paragraphs of the plea that they have their house on the particular land, my lord,
Yes.
my lady.
So your position is that it wasn't pursued in cross-examination, it wasn't proved in evidence. And we'll hear from the respondents in due
Yes.
course what they say about it. Okay, so that's the House.
Yes.
Thank you.
Yes. Yes.
Right, what's the next one?
And this, so this is also tied to the questions that were raised on the
Yes, thank you.
by the Lordship. Yes. This is with regard to the second ground of appeal, my lord. On the third ground of appeal, again, the third ground of appeal is in respect of whether it was an action personnelle, and therefore, given that the plaintiff disclosed an action personnelle as based on the requirement of asking the affidavit prescription, therefore it was time-barred, and the time limit was 10 years at that time. My lord, my lady, again, this is a very novel point that was raised on appeal. It was never raised at the trial stage, and again, the appellant did not have a possibility to defend this before the trial judge.
Yes.
And on appeal, it was difficult to bring any evidence to substantiate that it was not an action personnelle, but rather an action réelle, and if at all, an action mixed.
But I mean, that,
And
why
such-
would that depend
Yes,
on
ma'am.
evidence?
Yes, precisely.
Surely you can see from the plate whether it's personal or real, and I would have thought that where your claim for the ownership of the land was an action réelle. Is that not right? I mean, I can
Indeed,
see
my lord.
the arguments about the affidavit might have been personnel, but your claim for an ownership of the land certainly, to me, would seem like an action réelle. Is that your position?
Yes.
Yes.
Yes, this is indeed our position, my lord. However, I was stating that when this matter has been taken for the first time on appeal before their lordships, then their lordship misdirected themselves into construing. First of all, they misdirected in construing that it was not based on acquisitive possession. Then they came to the conclusion that it was disbarred. It was disbarred and prescribed by a 10-year limit, which it is not so, my lord and my lady. The case of the appellant is one based on droit réel because it's coming to court to request court that he is trying to establish acquisitive right on a property. And this cannot be otherwise than an action réelle.
Yes, well, I understand that. So that's ground 3, was it?
Yes, this is ground 3. And to this respect, in my written case, my lord, I have made reference to case laws such as Ramjatan and Gowri, but I will not be reciting or submitting them here because they've been clearly exposed in the written case of the appellant.
Okay.
Could I ask one question?
Yes, my lord.
Is the assertion of a right of property, a right of ownership, something that extinctive prescription can apply to at all? The reason I ask that question is because extinctive prescription is concerned with delay in the assertion of a right after the right has come into being. But the right of, the assertion of ownership is something, if I own a house, I can vindicate my ownership today I can vindicate my ownership in a year's time or 2 years' time. My right of action continues as long as I am the owner. And what I have in mind is Article 2269 of the Code. I don't know if you have that in front of you.
Yes, I do.
Because 2268 establishes the general rule that all actions réelles prescribe at 30 years, but 2269 clearly makes an exception to that in relation to an action or revendication. So if you are conducting a vindicatio rei, an assertion of your ownership, if you're dispossessed, that is an action which it doesn't prescribe extinctively, but merely is excluded by the other person getting acquisitive prescription. Yes.
Indeed, my lord.
Yes.
Indeed.
So
this is indeed this.
Yes. So if the hypothesis is, as your client would have it, that by 1976 he was the owner of the property, and had therefore excluded the interest of the title holder to the extent of the 37 3/4 purchase, then would it not be the case that in order to undermine his ownership, the title holder would have to gain occupation and assert acquisitive prescription, which, because he was a title holder, would be a 10-year period under one of the other articles. I think it's 2263.
Action personnelle. Yes. If I may, first of all, my lord, the extinctive prescription would apply to, if I put it like to a debt which is owed. It is not with regards to an immovable property, but just to take that to a debt. If someone owes a debt and the other party does not request payment of the debt within the time limit, then the term of the extinctive prescription would be utilized as a defense, because otherwise the person would abuse of interest rates, etc., etc. For the property rights, if I have been in occupation for 30 years, it means if ever there was a rightful owner, then the rightful owner didn't do anything for 30 years, so he simply loses his right over the property, which, let's say, I have enjoyed for 30 years in a peaceful manner. So the extinctive prescription would not find its application in the way that it would apply in the way that a debtor and a creditor uses it to extinct its droit de créance.
No, but there are, we see from 2268, some actions
Yes.
in rem which would prescribe, and presumably in relation to movables, if you have allowed someone to possess, if you have surrendered a movable, then you could be faced with extinctive prescription if you try to reclaim
Yes.
it. But if you're dealing with immovable property, is it not the case that 2269 indicates that your entitlement to vindicate your right doesn't extinguish by the passage of time, but it only extinguishes if someone else is able to assert acquisitive prescription against you?
Yes, I would read 2229, my lords, my lady, to be applicable for an immeuble, which would be like a house and not bare land. Because 2269 les dispositions de l'article 2268. Therefore, the action réelle being prescribed by 30 years would not apply, ne s'applique pas à l'action en revendication intentée par le propriétaire dépossédé de son immeuble. L'immeuble here, I would take it for a house.
It's a house rather than the land. But I mean, is immeuble
Yes.
not just immovable?
It is an immovable property, but it would not be like bare land.
So your understanding of 2269 would only apply to a house? Right.
This would be my reading, my lord, because it says when it is an action en revendication, and then the next paragraph speaks, and if we go back to, as you rightly pointed out, under Article 2263 and 64, we see that it is about justice, un immeuble, et le propriétaire est domicilié hors de Maurice, and I would take it, my reading would be for the, in respect of the fact that this is not with regards to land, but with regard to.
Yes, so well, that's a red herring then. So you're accepting then that if you didn't raise an action within 30 years of establishing your ownership of land, then with 30 years of your acquisition of ownership, then the right would prescribe. I wonder about that. I mean, can a right of ownership of land prescribe? Once you've got it and no one's dispossessed you, does it disappear by extinctive prescription?
It will not disappear, my lord, if this is where la possession ne doit pas être paisible. The owner should not do anything for the 30 years because it's a long lapse. This is where this lapse of time has been increased to 30 years to allow the real owner to put a claim, to stop the possession, to be paisible, not to be, as it has been established in the paragraph 2, that it was au vu et apparent. So every other people have been seeing that that person is utilizing the property, but nothing is being done by the real owner. He has 30 years to put a claim to stop that non-equivoque and paisible occupation.
But if the real owner who has acquired a right by acquisitive prescription has continued to possess and obtain the fruits from the property, I mean, why should that person have to litigate to seek a declaration that he's an owner? If no one's dispossessed
No,
him.
I was... Oh, right. No, I was speaking on behalf of the Domun, that the defendant ought to have...
Well, it may. Yes.
At the moment, I'm not understanding how this point arises. Your case is by 1976, you had acquired the title by possession. You brought your action in 2003, which was less than 30 years later. So even if there was a 30-year time limit, you were within it. Is that right?
Yes, and I have been utilizing it in a peaceful manner,
Well, that's
in
another
an
point.
apparent manner.
Yeah.
Yes.
Yes, but clearly your case doesn't depend on this point. I mean, if you're right that that your client's father gained ownership by 1976, you'd argue perhaps it was 10 years earlier if the 20 years applied. But in any event, the worst for you say you got ownership by 1976 and you've raised this action within 30 years.
I've got ownership, I'm stating, before those 30 years. I've used it for more than 30 years. And in 1976, I've placed the request because I have been always being harassed by the defendant. So I go for the prescription mode of acquiring the property. There are objections which are raised, then I come to court. My case is that for more than 30 years, when in 1976 we placed, although for the purposes of the law, it required 20 years of occupation.
Yes.
Right.
But are you content that we proceed on the basis that you have to meet, because you say you're an action réelle, your position is you are subject to the requirement of Article 2268? Is that your position?
Yes, yes, I am under action réelle, and I am not making any claim based on action personnelle,
Yes.
because the point raised on appeal was that it is an action personnelle,
Yeah.
and the lordships also have maintained same. This is what we are raising on appeal, that this is not true and this is not so. It was an action réelle, and therefore 1976 to 2003 we were well in between the 30 years for the application
I
of
think
the
we better
case.
leave it there. We'll see how Mr. Dulu puts it in due course.
Thank you.
Thank you.
And now, my lord, moving on to the fourth ground, the failure of joining all the heirs of Lika Kawol. And again, a novel point raised on appeal, which was not raised at the lower trial court, because had it been raised, all it would have required probably was to amend the title of the claim. However, even not having put all the heirs in the claim does not make the claim fatal, as declared by their lordships on appeal. I would submit so for two reasons, my lord. The very first one being the fact that the rule of Supreme Court, Rule 19.1, which is at page 657 of the electronic bundle, and probably in the
Page 15 in the paper bundle,
in
or page 17. Or 1960, page 16, sorry. This is Rule 19, the addition or substitution of a pursuant.
Yes.
yes, my
This
lord.
is, yes,
Yes,
we've got
indeed.
it in page 16 of the hard copy, addition and substitution of
It's-
parties. Is that the one?
Yes, it is the same in the primary authorities, my lord, at page 16. The rules of Supreme Court, Rule 19, subparagraph 1, my lord, any misjoinder or non-joinder of parties shall not defeat any cause of action. Sorry, my lord, it's a bit not legible. And
I think we can read it. It says, any
the court,
misjoinder or non-joinder of parties shall not defeat any cause of action, and the court may deal with the matter in controversy so far as regards the rights and interests of the parties actually before it. So you say, well,
thank you.
they could deal with the
Yes.
parties actually before it. Yes.
And it causes no harm, no prejudice to nobody, and therefore the claim was rightly entered, and it was not fatal as put in the by their lordship in the appellate judgment. Second reason why it would not also matter and be fatal, my lord, would be reliance is placed on Article 813 of the Civil Code. And Article 813 has been provided the day before, whereby we have done an interpretation of Article 813 of the Civil Code, my lord.
What does that deal with?
With indivisaire, the right of
Yes.
this is the very document I was which I wanted to place earlier on, my lord. This is at page, the document that was submitted on the 16th of July. It forms 4 pages. And it starts with the electronic bundle, page 176.
Yes, I don't know, have we got it? Is it in French or English?
It was in it. We are providing the French and the English translated version in
Yes.
the last page of that document, my lord.
I see. Well, why don't you read out the English version that you're relying on?
Yes, indeed. Yes. The Article 813, my lord, of the Civil Code of Mauritius provides that any undivided co-owner may take the necessary measures for the preservation of the undivided property.
Yes.
And therefore, the plaintiff, the appellant, being one of the co-owners of undivided rights, he was entitled to bring the case and before the Supreme Court. And for the purposes of my submission, I have also made reference to two case laws, but particularly Chu Ping Fen, 1998,
But do we
and in
need
this
cases?
case, my lord,
Isn't that fairly clear from your point of view? I mean,
yes,
Section
it
813 seems to say that you can bring your action to defend the property.
yes.
Yes.
Yes, my lord, indeed. And I was submitting the case law simply to elaborate that, in fact, Article 813
Yes, I mean,
disposes of this point very clearly.
It might have been said that 813 might be confined to necessary measures of urgency, but you rely on the Chu Ping Fen case for
Yes.
authority that an action to vindicate a right, an action to assert ownership, comes within 813. And it's on page
Yes.
26 of the paper bundle of authorities, where
Of authorities.
where it's referring to a case from the Cour de Cassation and also the Recueil d'Ayos.
Which page is that?
26.
26. Right, well, we got that point, thank you.
Yes, indeed, my lord. And whereby on page 26, the quote of Recueil d'Ayos, where it is clearly stated that such action can be taken by the indivisaire alone.
Yeah.
To protect the rights of the co-owners, yes. An action, a revindication action to protect the rights of owners comes within the category of acte conservatoire. That's the point you're making.
Yes, action conservatoire.
Thank you.
Indeed, indeed. It is therefore our submission, my lord, that
Thank you.
that the failure to have put the heirs is not fatal, my lord.
Was this,
On the fifth,
can I just ask, Ms. Sukun, you didn't appear in the Court of Appeal, did you? You
I
didn't-
did not.
No. Do you know whether these points were made in the Court of Appeal? Did anyone refer to Articles
Yes.
813?
Yes, my lord, they have all been made. The then lawyer had even submitted it is found in the proceedings that he submitted on all these points, and we see that their lordships have nevertheless come to their conclusions that they have arrived.
All right, thank you. Right, does that...
On the fifth, yes, the very last ground, my lord, the fifth ground of appeal, I would only refer to my written case, my lord, where I make an analysis of all the evidence given by the witnesses, the different witnesses, and how they were hardly cross-examined. Their evidence have been hardly challenged, where we have all throughout brought such witnesses, such as Mr. Ramanan Seebun, who was aged 82, and where
Well,
the
we've
then
read the
plaintiff.
judgment, and you helpfully, in page 23 of your case, you summarise some of the points
Yes.
from that, and
Yes,
we've got
indeed, my
that.
lord. And I have made a table. Sorry, my lord.
And you say there that since Mr. Ramanand Seebun said that he knew the land from when he was 5 years old, that you infer takes one back to 1933, 1934. Is that right?
Yes, my lord.
Yeah. Well, I think
Indeed,
we read
he
that.
has.
Yes. So anyway, we've got the summary, your
Uh,
summary of the evidence, and you say that was enough to justify the judge's conclusion. Yes?
Yes. Yes. And I made a chronology of the different dates of with all the submissions and the documentary evidence, the evidence given by Mr. the middleman, the document that have been produced.
This is at
The
page 26 and 27, is it?
I'm sorry, my lord, I have lost my document at the moment.
I'm looking at the moment at your case, dated 10th of June,
Yes.
and I'm looking at
Yes,
page
they are in
26.
I have in the chronology bundle. So this is where I am. But it is exactly my written case, my lord, which has at page 24.
Yeah, page 24,
And
you summarise the evidence,
and onward.
and that's your case is what the position was before the judge.
Yes. I mean, the critical point,
Yes, my lord.
if you needed 30 years, your position is, in fact,
Yes.
back in 1976, you only needed 20 years. But if you did need 30 years, the critical evidence you found on is that of Mr. Ramanand Seebun, who was the elderly gentleman who made it clear
Yes.
that the grandfather of your client had been occupying the land and growing cane on there before he died. And we know he died in 1946. So that gives you your 30 years. That's really the key point.
Yes.
Yes.
This is indeed the point I have highlighted in the chronology of dates, my lord, found at page 26 and 27 of my written case,
Yes, indeed.
whereby with the birth of Mr. Ramanand Seebun, when he says he was 5 years old, and from there on he knows about the Pitamba Kowal, the late grandfather, being in possession and occupying the said property, a minimum calculation of 1946 to 1976. This is where the appellant establishes an ownership of an occupation of 30 years, and taken together with the district court judgment and the lack of any documentary evidence brought by the respondents about their occupation, simply aver that there were sugar canes, but they do not mention about or bring any document or any witnesses of any kind, except for the two witnesses that have been cross-examined, my lord, in my lady, and we see that they hardly meet any level of to destroy the balance of probability case which has been brought forward by the appellant.
Good. Well, thank you very much. That completes your presentation, does it?
This completes the presentation on the ground of appeal that has been raised, my lord, and except that my friend appearing for the respondent has taken matters extraneous to the ground of appeal and has presented in the written case, such as the memorandum of survey, the different aspects
I think it'd be better.
whereby, my lord.
I think it'd be better if we let him take his points and you can object and you'll have your reply. But we've got your case. We're coming up to 12
Yes.
o'clock, which I think was the end of your time. So I think the best thing
Indeed,
is if we hear Mr. Dulu now and we can see what points he's making and how he responds. Yes, Lord Hodge has one point.
Yes, the parties are working on the basis, am I right, that when the respondents lodged their notice of objection to the affidavit of prescription, that was a sufficient step to interrupt any acquisitive prescription. I just wanted to confirm that, that the parties are presenting it to us on the basis that Article 2244 covers an objection in those circumstances.
Yes, le possesseur actuel, indeed, my lord. So the present owners, which is found in the primary authorities, Article 2234, on the second page. The present occupiers, the appellant, is establishing all the 30 years for all the ownership done by his late father and the grandfather.
No, sorry, you have misunderstood my question. I was referring to Article 2244. And I was asking,
so sorry, my
I was
lord.
asking whether an objection to an affidavit of prescription comes within the definitions of a citation en justice, un commandement ou une saisie.
Okay. I know that, yes, indeed, that 2244 have been produced by my friend, and
Well, I don't want to take up time just now. We can come back to it and answer. But you've been working on the basis that the objection was sufficient to interrupt prescription if it hadn't already been completed.
I would even submit, my lord, that at 1976, the fact that they have raised the objection, if it puts a stop, but then the 30 years is before the 1976.
Yes. But so just to make sure you understand, my question is, you are accepting that the objection falls within the terms of Article 2244. You can answer it in reply if you want, but I wanted to be sure about that.
Thank you, my lord. Yes, thank you very much. Thank you.
Right, thank you very much.
And now, my lord, I will be moving from this place so that I allow Mr. Dalu to be seated here.
Thank you.
Yes. Thank you very much.
Thank you.
Thank you very much, my lord, my lady. Yes.
Yes, Mr. Dalu.
Yes, thank you, my lord. May it please your lordships and your ladyships. I appear for the respondents, instructed by Mr. Attorney Basani Rangasamy, who is by my left here. And I would start on the very point that has been raised by your lordship just now regarding Article 224 and the interruption of prescription. And may I refer your ladyships and your lordships to the judgment of the trial judge, more particularly at page 163.
Yes.
Where the trial judge stated, if I may just read through those few lines, the question of plaintiff himself having been in actual occupation as from 1999 and up to now does not arise, nor has any significance since objections were taken by the defendants as from 1976, when late Leka Kawal tried to transcribe his affidavit of prescription with the conservator of mortgages, so that it was incumbent on the plaintiff to prove on a balance of probabilities that his father, late Leka Kawal, had, prior to 1976, occupied the land in Lite with all the requisites of prescription. So, your ladyships and your lordships, in the light of this finding of the learned trial judge, I will start by asking and replying to this question: what was the course of action? And we have laid emphasis on this in our written case and also in our submission before the Court of Civil Appeal. The course of action is clearly, if we go through the amended plaint with summons, which is found at the second amended plaint with summons, found at page 3640, an ample reference was made to this whilst my learned friend was submitting. You would see the whole plaint, the course of action, is in regard to the transcription of the affidavit of prescription and also in regard to the objections made by the respondents. So, the plaintiff, appellant now, has, by virtue of paragraph 6 at page 38, said that these objections were unjustified and frivolous. And therefore, it is for them to prove what they are averring, for the plaintiff to prove what he's averring, on a balance of probabilities, of course, and it is for the defendant also to establish that they have made valid objections. And this being, and the issues were joined on this. And I have underlined this in my written case, that it was late. On the trial date, that amendment was made to add the hairs, and that to paragraph of the prayer, the prayer, paragraph 9b, and his heirs was put in. Why? I humbly submit, and with all due respect to counsels of the other side, that it was when realizing that it would not be possible to prove the averments, the alleged averments in the affidavit of prescription, and also to join issue with the defendant, now respondents, in regard to the objection, now that they shifted, and I've underlined this also in my latest reply that I gave yesterday to the queries that was made by your ladyships and your lordships in regard to this question of occupation. And you would see that I stated clearly that the heirs was mentioned there, and there was the relevant question asked just now by your ladyships and your lordships. How about the heirs? And also, in the very beginning, the committee submitted to us the issues to be considered, At C, we see the failure to join all the heirs of the disease, whether this was fatal to the claim. And I will submit here, and we've answered this already in our written submission, but I will answer this to say that it is. Because this is not a case of revendication. This is not the case of one of the heirs taking mesures conservatoires. That is, in order to protect their ownership. Because they are not owners yet. They have to establish their ownership. They have chosen to prescribe the land by affidavit of prescription, and to become owner, it should be transcribed by the conservator of mortgages under the Affidavit of Prescription Act. So Lekakewal is not yet the owner. Therefore, how could they become the heirs?
But I'm sorry, I'm not.
And this is why.
I'm not sort of understanding this, Galu. What is said on the other side is that this amended plate is asserting that the late Lekakewal had become owner by virtue of 30 years' occupation, and that's what it is said was proved.
Yes.
Now, I can see that there are problems about the affidavit of prescription if we don't have it. But why was it not good enough for them to claim that they own the land and to prove that they did own the land and to get an order to that effect?
Yes, thank you, my lord. And this question would be linked with various issues before your lordship. The question of the conservator not being joined as a party, and also the question of the content of the affidavit of prescriptions not made there. It was not made available. And therefore, this is why we are suggesting humbly that the plaintiff at the 11th hour shifted its course of action and now is claiming that the course of action is as per paragraph 9. But I humbly submit that paragraph 9 is only in support of the affidavit of prescription, because my learned friend has said that at paragraph 7, the plaintiff has averred that Lekakewal had already become the rightful owner of the portion of land. And this is the course of action to come before court to prove that he has been in possession for more than 30 years as required by the Code Civil, and therefore this is disconnected completely with the question of transcription of affidavit of prescription and all that. But then if we continue reading the same paragraph 7, we would see has become rightful owner of the portion of land described in paragraph 2 above, and described in paragraph 2 above by acquisitive prescription, and that the objections formulated by the defendants, number 2 and 3, and late Bansilal Domun, the other brother, against the transcription of the affidavit of prescription should therefore be set aside. So this also, all the facts averred in paragraph 2, all the facts averred in paragraph 7, the prayer in paragraph 9b is in connection with the possession and occupation prior to the affidavit being registered with the conservator of mortgages, containing those facts as averred in paragraph 2 of the plain. Therefore, they are saying, this is what we've said in paragraph 2. And they, of course, they have to do it in the affidavit of prescription, and before the competent court, when they come to challenge the objections, they have to aver their occupation during the prescriptive period. This is what they've done, paragraph 2. So therefore, the action is not one of coming to prove that I have become owner now. I want the court to examine the facts that for more than 30 years, I have been occupying with all the requisites of acquisitive prescription, and therefore you declare me owner by your judgment. And then I'll transcribe, as my learned friend has said, I'll transcribe this judgment with the conservator mortgages, then I'll become owner, and I can exercise all my rights on that particular property. Whereas the issues were joined on what, my lord? The issues were joined on the question of the affidavit of prescription, whether it is valid or not. We're saying that it is null and void, and also on the question whether the objections were unjustified and frivolous. This is what they've said, qualifying the objection unjustified and frivolous. And we thank the plaintiff for having averred at paragraph 5 all the grounds of our objection. Now, it is for the trial court to decide whether those objections were valid or not, whether they were unjustified and frivolous. And if your lordships and ladyships would allow me, I would here refer to the Affidavit of Prescriptions Act, where
Yes,
this is very important.
Let's look at that. It's in our authorities, yes.
Yes, it
Page
is
33 of our bundle of authorities.
Yes. Well, my lord, we have referred in our written submission, and I have to offer you all my apologies here to page 33, as you've just stated. But I would rather go to page, I think it is page 96, rather. Page 96, rather, my lord. We would rather refer to page 96 to page
96.
99.
Is that the same act?
Yes.
I see. We got it twice.
It is the Affidavits of Prescription Act, but
Yes.
as enforced at the relevant time.
I see.
Because the one at page 33 has been amended in 2010, 2011, and all that.
Oh, I see.
But in substantially the same thing.
Yes, okay. Well, we got it as
The main
amended
section.
as at December 2009.
Yes.
Yeah.
Well, the 2009, and we have the copy of the original Affidavit of Prescription Act. There has not been much change. You would see at the footnote of each section, you would see the act that would come to amend, but they have not made a consequential amendment. It is mostly regarding the duties, the taxes, and all that,
Yes.
except that paragraph 3, subparagraph BA, as you see, BA is an addition. It's added by Act number 2 of 2009.
But I mean, that's just proceed.
But this, I will not rely on this. I will not have to rely on this, because the material part is paragraph, section 3, A and B. This is very important, and this is how it was in the original and as the law prevailing in 1976, and 1999. That is 76, when the affidavit was allegedly sworn, and 99, the death of late Leka Kewal. So paragraph 3A, so the affidavit of prescription shall be transcribed, paragraph 3, shall not be transcribed unless the affidavit contains a mention of the situation, description, and exact boundaries of the immovable property forming the subject matter of the affidavit, and the open market value of the property at the time of completion of the statutory period for prescription. And then B, unless the affidavit contains the date, this is very important, the date which the occupation started and is accompanied by a plan and all that. Of course, when the plaintiff came to lodge the plaint, they averred in paragraph 2 all the details that was required, but they didn't mention the value. And then also they did refer allegedly to a memorandum of survey. But this is also contested, my lord, I'll come to that later, to show that in many respects, the affidavit of prescription averred in relevant paragraph of the plaint, based on the definition, the delimitation of the land given in paragraph 2, would not satisfy the affidavit of prescription. And this is why, my lord, I thank your ladyships and your lordship, when we had those queries the day before yesterday regarding this, where is the affidavit of prescription?
Well, I
Of
think the
course,
answer is
the only
no one knows. But, I mean, as I read the Act, there's nothing in it which says you shall not bring an action unless you have an affidavit of prescription. As I understand it, the
Yes.
plaintiff's position is that she's entitled to prove her ownership with or without an affidavit of prescription. And indeed, if we go to section 12, which tells us about the effect of transcription, it makes it clear that it doesn't confer any rights on the parties. So what I don't understand is why you're saying that the affidavit of prescription is so important. Because if she can prove her title anyway, why does she need to rely on the affidavit of prescription?
Yes, this is why I state, and this is why their lordship and ladyship at the Court of Civil Appeal queried this with the counsel there. You would see in the proceedings that when the proceedings were starting, asking, where is the affidavit of prescription? What is your cause of action? Your cause of action is not
I'm
one
sorry, you're not,
of
Mr. Dulu.
courtship.
As I understand it, the cause of action is based on her claim to own the land having been in occupation for 30 years. As a separate matter, she's saying, well, there was an affidavit of prescription. But why is she not entitled to assert her claim to ownership of the land without relying on the affidavit of prescription?
Yes, because that was not the case, my lord. With all due respect, that was not the case of the plaintiff right from the beginning. On what were issues joined? See the plea of the defendant. The plea in defendant is in regard to the affidavit of prescription and in regard to their objections. Had it been the case of establishing ownership of the land right from start, then the defendant would have joined issue on that, but not join issue on affidavit and prescription and objections. You would see. I'm sorry, my lord.
My Lady Black has a question for you.
I just want to put to one side your argument about what the case was about when begun by the claimant and ask you, is it possible to establish by prescription ownership of property as in accordance with what it says in 22191 of the code without any affidavit of prescription? That's a question completely aside from your other arguments. Can it be done?
Yes, my lady, definitely it can be done.
Thank you.
Can be done, but with the proper procedure, with the proper course of action in your plaint.
No,
Your plaint
I'm
should
asking,
come and say,
sorry, I'm asking a question which is not to do with that. It's a question of law. In law, can
Yes.
you get a property, as I think it is the implication of 22191 of the code, without ever having an affidavit of prescription? It might be needed to prove your title later, but you own the property before the affidavit of prescription and the registration.
yes, my lady.
You accept
And
that?
with all due respect, I've done it on many occasions.
Fine. That's the question. Thank you very much.
And but you should aver it in your plaint and join issue with the parties. Because here, had it been so, the defendant would have come and have a different defense. Not just asking the question, you would see in the demand of particulars, only 2 questions were asked about the occupation and about communication of the affidavit of prescription. And I've replied that in my letter of yesterday, that there was no answer because the plaintiff answered it was not available. Then
Well,
we
but
put our plea.
was that objection taken at the hearing? Did anyone object, say you can't prove this case because you haven't got the affidavit of prescription? We don't see any reference to it in the judgment. Was that point taken before the judge?
No, there was no need, my lord. As far as the defendant is concerned, it is for the plaintiff to come and show that the affidavit of prescription complies fully with the requirements as per the Affidavit of Prescription Act. And we've done our part, the defendants and the respondents have done their part by filing a notice of objection with the register. If you would see, my lord, if I may again refer you back to the Affidavit of Prescription Act, more particularly now paragraph 4, section 4 rather, at page 97. So you would see that the affidavit would be duly registered and given election of domicile in Port Louis, the conservator of mortgages, and then there's a register. Therefore, the question asked in question number 1 and 2 the day before yesterday was where it is. It should be. It should be probably. I say probably why? Because 1976 to 2019, or if we take the date of the lodging of the plaint, 2003, how many years? Do they keep the records of documents which have not been transcribed? Because if you look at the Affidavit of Prescription Act, what it says concerning the objection, the application.
May I interrupt you just briefly?
Yes, my lord.
Because
Yes, my
cut
lord.
through this point. We do not know either whether the affidavit of prescription still exists, and if it doesn't, then we can't make an order on the conservator of mortgages to do something which is impossible. Secondly, even if it does exist, we do not know if it complies with the Act. So we cannot order the conservator of mortgages to record, to transcribe a document that we don't know whether it complies or not. So I think, for me, for one, you're pushing at an open door if you're suggesting we cannot transcribe, order the transcription of the mortgage.
Of the affidavit?
Yes, my
Of
lord.
the affidavit,
Thank you,
I'm
my
sorry.
lord.
Yes, I mean,
Yes.
that, I think we accept to that extent subject to anything that's said on the other side, that insofar as the judge tried to order the transcription of the affidavit, that couldn't be done without the document. But that doesn't, as I see it at the moment, affect the claim to ownership by virtue of 30 years occupation.
Yes.
And what seems to us, I think, speaking for myself, slightly strange, is that the Court of Appeal treated the issue as turning solely on the affidavit of prescription and didn't go on to consider, well, have they nonetheless established their title by virtue of occupation?
Yes, my lord, I fully agree. But then what is the case before your lordships and ladyships now? The case is as per the plaint and as per the pleadings, as per the issues joined.
Well, what is said, as I
Now,
understand
if
it, is
this
that
is the case,
if you look at the plaint, you can see that there was a claim for an order that they owned the land by virtue of occupation. And it said that the Court of Appeal didn't deal with that.
yes, this is as averred allegedly in the affidavit of prescription. But then, my lord, if I may, I hope I'm not being too stubborn on one particular point, that I mean that if this is the case, this is why the Appellate Civil Court of Civil Appeal said that action was misconceived. And this is why they did not dismiss the the plaint. It was set aside, the objections, so that it was just purely set aside, and it was purely struck out, which means that the Seebun, the heirs, siblings, and all that, they would not lose their right of action before our court of law. So if the plaint is dismissed, Seebun and any other sister and brother and all that can enter a plaint of ownership with all the facts averred, and the other party, the Domun or whoever, can come and join issues on those facts. This is why you would see that the Domun didn't, it would have been simple if the Domun had come with all their survey, with photographs of their building, with everything. They didn't have to do that. What they had to do is to show that their objections were valid. And this is why. Why the affidavit
bear with me, if you will. I mean, you say that if you thought that you were facing a claim of acquisitive prescription by occupation, you'd have led different evidence. But if you look in paragraph 5 of the amended plaint with summons, your objections were that you were the title holders, that's A. B, that Leka Kawal had never occupied for 20 years, as alleged. C, that the affidavit was false, we can leave that to one side. And D, because you had built houses on the disputed land. So the issues which would have opposed the claim of acquisitive prescription were precisely the issues which had to be set aside, had to be dealt with to set aside the objection.
Yes, and this is exactly what the learned judge, trial judge, tried to do by finding, and he said so, by finding that the prescription was valid, by finding that the ordering the conservator mortgage to transcribe. And this is why also it was found, and we support this finding, that the action as such was a personal action personnel, because you would see how do you contest an objection of an affidavit. It is for the one claiming to be owner that should go to the judge in chambers. Here I would refer to the objection, paragraph 8, and then how to go about it. You go to the judge in chambers within a delay.
Sorry,
of
where
3
we
months.
go? Sorry, where do you want us to look now?
It will be section 7 of the Affidavit of Prescription Act, page 97, continuing on to page 98, 7 and 8. So any interested party may, within 3 months of the date of service of the conservator of a notice of objection, apply to a judge in chambers for an order setting aside the objection, given 3 months. And the judge in chambers is on affidavit. It's an affidavit procedure, averring the facts, and then if the judge in chambers comes to the conclusion that evidence should be heard, people should be heard and cross-examined as to the facts, then the trial judge would refer it to the competent court. So where they're hearing the parties, and after considering the grounds on which the objection is based, the judge is of opinion that the objection is frivolous and unjustified. This is as averred in our plaint here, frivolous and unjustified. He shall make an order setting aside the objection. But where the judge should otherwise, the judge should refer the parties to the competent court. And the competent court, this is the competent court, the trial judge, the lower court was the competent court. Either the judge, if the application was made within the 3 months, the judge would refer it to the competent court, and if the person does not do so, that's his business. But here, they didn't do anything from 1976 onwards, and now they go to the competent court. Now they go to a competent court to ask that the objections were frivolous and unjustified. And then we have the value of an affidavit of prescription. And of course, if your lordship would come to the conclusion that this is a case where the plaintiff has come to establish ownership of the land and not for the objections to be set aside for transcription, then of course what I would say may not apply. But then we have the question of transcription of affidavit, and then there is the prohibition, no affidavit of prescription, section 8, in respect of which a notice of objection has been served on the conservator shall be transcribed unless the objection is withdrawn by notice served or the conservator, or there is presented to the conservator either an order of a judge in chambers setting aside the objection or a certified copy of the judgment of a competent court deciding the issue. My learned friend has referred to the question of transcription of Mortgages Act and all that. But here it is provided, if the competent court would find that the objections were not justified, set aside the objections, then would order the conservator of mortgage to transcribe, and the only thing that Mr. Seebun, the plaintiff, would have done in the light of the judgment of the trial court, if the judgment of the trial court now is confirmed, Mr. Seebun, the plaintiff, just goes to the conservator of mortgage and say, transcribe this affidavit, I become the owner, in the light of the judgment. And this is why there was an appeal, because once the judgment was delivered, had the plaintiff who won the case, in the light of the judgment of learned Justice Angu, gone to transcribe, he would have transcribed and become owner by virtue of affidavit of prescription. So this is why, my lord, if I may, with all due respect to the remarks made by your lordship, I would insist and say, this is why. This is a personal action personnelle. The delay is very important because what is being done, the Kewal or the Seebun are attacking the objections of the Domun. It's a personal action, the action taken by them. It's not the question of attacking ownership of whoever. So this is why they've come just to say, this is my objection. I have my title deed. I'll come in a moment to this, my lord and my lady, concerning the title deed of the respondents and also the evidence that has been ushered in regarding the occupation of the property, possession, because possession and occupation is not action réelle.
Yes. Can we just pause a moment? I think Lady Arden has a question.
We have to give weight to every allegation in the plaint. You are pointing us to the paragraphs which deal with the declaration in paragraph 3, the objections in paragraph 5, and the prayer for relief. But we have also the allegations in the plaint in paragraph 2 of occupation of a specific piece of land, and the title of the heirs. There is not simply one case but based on the affidavit. There is another case based on occupation, as it seems to me. And it therefore, while you may be right that the court could not proceed on the basis of the affidavit, that didn't dispose of the other case dealing with occupation.
Yes, I think, do you want to answer
my
that?
lady. May I know to which case you are referring?
Well, I think it's a point I put to you earlier that whatever you say about the affidavit of prescription, the judge also had to deal with a case based on occupation and ownership. And he found that there had been ownership by virtue of occupation. And that's quite apart from the objections to the affidavit of prescription. And what I think my lady is asking is, well, what's your answer to that? What's your answer to the case based on occupation and ownership?
Yes, my lord, because the trial judge had definitely to make a finding regarding the occupation for that period. And this is where he went wrong by saying that he has become the owner. Because he's not yet the owner, he'll become the owner by virtue of the transcription which he's ordering to transcribe.
But I think this is what
Because
I think this is what we're not understanding. Why do you say that you only become owner by virtue of the affidavit? Why can't you become owner by virtue of the provisions of the code which say that if you occupied for a certain period, you become owner?
Yes. My lord, there would be two ways to do that. Either, as I've stated earlier, you enter a plaintiff summons, depending on the value of property, you go to the Supreme Court, and then you say that I have occupied for so many years, I've become owner. Normally, the advice would be given to that person, we go and have an affidavit of prescription and transcribe it. It's the easier way, rather than going to court to establish all this. But if you want to go to court, let's go to court. Now you say that from this date to this date you've been occupying, and then nobody has occupied that, or somebody has been interfering with my quiet and peaceful occupation, or somebody has encroached on that land. I want that person to go now. So there you enter this court of main action, but you aver all the facts of your occupation, and whoever you are suing, the defendant, will have to come and join issue and come to prove. If he's saying that I'm owner, this is why I have encroached on the land, he'll have to establish his ownership. And in that case, most of the time, he may have an affidavit of prescription in order to answer in defense, or he may have a title. In that case, he would have the burden to establish his title as per the various case law that we have cited, we have quoted, that is, that he has purchased from somebody who had ownership, the previous owners and all that. During the period of prescription, those persons were owners, as we've been averring in this case. The other way to do it, my lord, if I'm occupying the land with all the requisites of prescription, somebody comes and wants me out by whatever right, whatever title and all that, or even he's a lessor or whatever, he wants me out. Then he comes and aver this, and I come in return to answer, I have been. And this is the best way to do it. The best defense you have is prescription in that case. To defeat the title of somebody, a plaintiff who comes with title, and if you can establish your occupation by prescription, and this is why in all the authorities we've put before your lordship, this is why you would see the prescription would prevail on title, unless the person can really prove the title. So there are two ways to do it in case of occupation. With the requisites of prescription, you enter a main case, as I've said, or in defense, you come and establish that you are the owner by prescription.
I see. Well, I think we have your submission on that. Could we turn to a slightly more specific point, this question of the houses? I think it said that there was no evidence led and no cross-examination on to support your client's allegation that they had built a house on the relevant land. Now, in your answers to the questions we put, question 5, you say that you did give evidence to support that assertion. I think we have some trouble with that. Can you deal with that point? Where do we find the evidence that your clients built houses on this particular land?
Yes, and I referred to some of the pages in my answer, my lord. You would see in paragraph 5, in answer to question 5, I referred to the testimony of Mrs. Krishnavati Domun. He explained how the land was divided into three, and you would see that.
Can you
in the report
take
at
us to the
page
relevant evidence in the translation?
Yes, I have referred to in my reply to record page 124, my lord. 100 yes.
Did you translate?
Yes, you would see that Mrs. Krishnavati Domun, the wife of late Bansilal Domun, would be saying that she has been occupying the land, and the house was
Sorry,
found.
which
First
page?
you have
Which page are you on?
at page 124, line 10.
104,
This translation.
120.
24.
124.
124.
Can we be referred to the translation? 'Cause I'm afraid some of our knowledge of Creole,
sorry,
French
my
is not very good.
Yes, but in the question, reference was made to the Creole pages.
Yes, I mean, we can get so far with it, but we better
Three?
see the translation.
Yes, 364, I understand.
364.
Yes.
Yes, this is
So,
Krishna.
or rather, it would start as 365 at the
Yes.
very top of 365. There were three brothers all together, all three brothers, etc. They all resided in the same yard. No, the land was the same but separated. It was the same land, but each had his own house. Whose land is first? Yours, Shantilal. From the right, it is mine, then Shantilal's, then Dharamdev's. Okay? So the position is this, my lord, and this will be confirmed later. The land in dispute, where the sugar canes were being planted, this is where Krishnavati, Domun, and late Bansilal were, with their house. And then you have the middle one belonging to the other brother, Shantilal, and then on the other side, Dharamdev, that is the one who came as witness in the court below. And this will be confirmed also, as I've stated in my reply, this will be confirmed also by Dharamdev Domun's evidence. That, I read at paragraph C, the land of Shantilal Domun, and then next to it, his own.
Which page, please?
And record page 132 and 138, the Creole version.
Well, we'll need to find that in the translation.
Yes,
So we
the translation, yes. I'm sorry, my lord, when that question was asked, reference to the Creole version, so I just followed on that.
Never
So
mind.
record page 102, the translation. My learned friend has kindly indicated to me that it is at 368.
368. This is Dharamdev, Domun, yeah.
Yeah, Domun, the Domun would start, but it is so the relevant part, which being the Creole version, 127 onwards, my lord. So it's 132. That would be the English version.
I mean, would you prefer to come back to this after the break, Mr. Because
Maybe, my lord.
Yes.
Yes.
Well, could I just refer you to 373 at the bottom of the page, line 16? Can you tell the court who are the neighbours who reside near the 37 3/4 purchase. We ourselves, my sister-in-law, my brother, and myself. That doesn't. We can discuss it after the break, but this doesn't seem to suggest that the houses were built on the disputed land.
Yes, this is their evidence, my lord, and this was never contested or contradicted by the plaintiff.
Yeah, but they're saying they live near the land, they're not saying they live on it. What you had to show was that houses were built on the disputed land, not that they were built near it. And my lord is putting to you
this is what they averred on their plea, and in evidence they explained the division of the land amongst the three, and they said that the Krishnauti was staying on the one third and the other one. But then I would like to point out, my lord, and fortunately the evidence was such that a lot could have been put before the trial court, but people in Mauritius, you have a house and around it you have sugarcane. This is the normal feature in Mauritius. I'm sorry to say that, but I was Minister of Agriculture for some time, and this is people behind their house, they have sugar canes, and they have all sorts of crops. And this is what they've said, my house was there, and the sugar canes also were there.
But we have to deal with this.
Regarding the sugar cane, they said...
We have to deal with this on the evidence before the court.
Oh, certainly, my...
We can't take account of evidence.
And the evidence is to the effect that my land was there, the sugar canes were also there. The father-in-law, and as far as the lady is concerned, she got married in 1982. And in 1982, we had the case before the district court for possessory action. And the possessory action is regard to 1 year.
Yes, I think we're getting away from the point. Mr. Dallo, could you just stop a moment? I think we perhaps better after, it's now 10 to 1, I think we'll come back after the break, and so you can point us to any other evidence in the translation which shows that there was a house on the 37 acres, because that's the point we're on. But we need to be clear what you're relying on. But before that, I think, could we perhaps take one of the other points which has come up, which is why it matters that the other parties weren't joined. Mrs. Sukun referred us to the provisions of the code which show that, in fact, the fact that other parties are not joined does not make the proceedings invalid. What's your position on that? I mean, are you still saying, as the Court of Appeal seems to have said, that the mere failure to join the other heirs meant that the proceedings were invalid?
Yes, my lord. And I would support this finding because when the plaint was entered, the plaintiff was not yet owner of the land. They've come to establish that they are owner. Now, at a later stage, they come to say that Lake Akewal was owner, and I myself, I was owner, and so were the heirs. But in order to establish that right, all the owners should have been joined in, because it is not a case of revendication or mesure conservatoire by one of the heirs or one of the co-owners. It's only when you're owner that you can enter a case of revendication, either owner by prescription, title deed of prescription, or owner by title. You come to vindicate your rights of ownership against that person. So any of the co-owners or any of the co-heirs can take such an action. There's no need to join the other party. But when you come to establish ownership in any person's name, you have to join all the persons claiming to be owners, co-owners, or co-heirs, or whatever. Why, my lord, I say this because I thank my learned friend to have referred to the rules of court and discussion now, because the joinder of parties will not, as provided for, cannot defeat the right of a party, but that party, where there's need to join, if the course of action is such that that party should join the co-owner, can make an application for amendment of the plaint in order to join that party. If we continue, my lord, if I may, it's not legible at all, this text.
We're looking at,
We look at Rule 19 and the reference. We look at
Where are we?
Rule 19,
subsection 1.
you got that
16,
page
yeah.
16 of the authorities, which is what she referred to, Rule
Yes.
19.
Page 16, that's right.
Yes,
That's right.
16, yeah.
So, therefore, if the action, and this is also important, if the action were one of establishing ownership by prescription, not relying on affidavit of prescription, then all the persons claiming to be owner should have been joined. And then the defendant can take the point. You're saying all those persons are owners, but they should be there. Then the court is bound to allow, not to deprive the person of his right, to allow an amendment of the pleadings of the plaint in order to join the relevant party. Yes, my lord? My lady? Yes.
Thank you. Rule 19 says any misjoinder or non-joinder of parties shall not defeat any cause of action. So why couldn't the court simply allow, if this point is correct, simply allow an amendment to add the names and then give and make its order dependent on giving a month to the parties to see if they objected to being joined? But we're told that the co-heirs did not object. They presumably were not living on the land. It was only the first co-heir, the plaintiff, who was. So given that the rules say that actions are not to be defeated by non-joinder, why shouldn't the court seek some pragmatic way of dealing with this problem if it's a good point?
My lord, if I may, my lady, if I may, if the action ab initio, the cause of action was in regard to the question of ownership, maybe yes. But now this is a different cause of action. This is why the Court of Appeal, Civil of Appeal, took this point that you are saying now, and in fact, it was before the Court of Appeal that, I would refer to that maybe later on. This is why immediately counsel for the respondent before the Court of Civil Appeal said, look, I've changed. I agree that we do not satisfy the prescription period. I agree that we are not going by affidavit of prescription. We want to go now by question of ownership. This is why the case was said to be misconceived. But in this particular case, this is a different case where, with all due respect, I submit that the Court of the Privy Council would not be able to substitute or to find a way out and say, or maybe order a new trial. Maybe order a new trial.
But you've moved the point.
Yes, my lady. Yes.
That is your argument on there being a concession. We've yet to hear that argument. But if you put that on one side, it would be open to the court if it found that a non-joinder point was a good one to find a practical way of dealing with it, and the court should take that approach because the non-joinder is not to defeat the action. We've got to hear your point about the concession in the Court of Appeal, I agree, but it's a separate point, non-joinder.
Yes.
But I mean,
This is my subject.
I think we probably have your answer to it, which is that there was a concession. But I mean, is there any evidence of concession?
I don't think the concession point is an answer at all, with respect. But as I understand it, you are accepting that if the cause of action from the outset was establishing ownership, then one heir could raise the action. But you're saying that's not what happened in this case. You say it was simply an affidavit of prescription action. Is that the point you're making?
No, if I may, my lord, with respect, I'm saying that if it were ab initio, the course of action was to establish ownership by prescription, then all the parties should have been joined.
Yeah.
Whereas in this particular case, to withdraw or set aside the objections, any interested party would have done that.
Yes.
The same way for a case of revendication. Once ownership has already been established, there's no need to join the other heirs or co-owners. But in this particular case, it should have been, and had this been a case of ownership, the defendant would have taken the point. They didn't take the point because this was not the case of ownership. And had they taken the point, then the court would have ordered the relevant amendment to be made to join the relevant parties.
But yes, the point wasn't taken at first instance. It came in at the appeal stage, as I recall. Is that right?
Yes, my lord. That was in answer to the new position of the appellant. Their new position being, forget about my case of affidavit of prescription. My case is one of ownership by prescription now. Forget about the rest. Then the question crops up that all the parties should have been joined if it were a case of ownership.
Right. And, I mean, we're told by Ms. Seebun that, in fact, the other heirs are quite happy with this action and don't have any objection. Do you have any reason to think anyone objects to it?
My lord, if I may, I thank you for referring me to this. If I may refer your ladyships and your lordship to some of the documents that have been produced, and more particularly, the document where the plaintiff claimed to have been authorized by his father to occupy the land. Authorization, that is document F at page 174. Document F at page 174.
Yes.
So we see this document just before their death. The father, Lekakewal, died a few days later. A few weeks later, the mother died. So on the 25th of March, 1999, we see this document where Lekakewal and wife authorizing the plaintiff, Seebun, to occupy, you would see on the third line before the bottom of the first paragraph, to occupy all our land that we possess at Cantorel. All our land that we possess at Cantorel. Mm-hmm. So, this, without description of the land, okay? And I would refer your lordships and your ladyships to other such documents where it is just a land at Cantorel. So without the description of the land in those other documents.
But
now,
what is the legal significance of this document? In a nutshell, this document is clearly related to an interest that the parties have in relation to the Sugar Insurance Fund board.
Yes.
But what is the legal significance in relation to title to sue?
Yeah, but the land was apparently handed over to the plaintiff Seebun to occupy. None of the heirs have been mentioned there. So it was in 1999, and the case was entered in 2003. And the case was entered without the other heirs.
Yes, we know that. The question I put to you was whether you have any reason to think that any of the other heirs are objecting to these proceedings.
Yes, are they aware of these proceedings to begin with?
Well, I'm sorry, we are told by Ms. Sukum, that they consent. But if you've got any reason to think they object, well, then that might be relevant. But anyway, I think at this point we'll adjourn for the break. It's now 1 o'clock here. I'm not sure what time it is there, but we'll adjourn now at 1 o'clock and come back again at 2. Can you give me an indication, Mr. Dullows, how much longer you need for your submissions in terms of time?
Well, I've taken already, I think, one.
You've taken just over an hour, yes.
Yeah, maybe.
You've got another hour if you need it, but you may not need it all. Anyway, we'll come back at 2 o'clock.
Maybe half an hour, three quarters.
Yes, that's helpful. But you'll be able to refer us to going back to the House, you'll be able to refer us to the English translation of the evidence for anything you rely on, will you? All right. Thank you very much. We'll see you again at 2 o'clock at our time. Thank you.